Yes.
Your Lordship, I pray that it may be listed after vacation.
No objection, Your Lordship.
When I'm on prayer with the petitioner, not objected to the line to consider of the respondents list of revocation. Yes.
Grateful.
Please, Your Lordship. Your Lordship, I beg to mention item number 7.
Yes.
Lordship, I'm praying that this matter may come up after vacations, Your Lordship.
Petitioner,
It's Mr. Chanda, sir.
is he here or is
I have already informed his local counsel.
Okay. This is 17. On prayer made with the respondent list of revocation. On behalf of the respondents, yes. 7. It's item number 7. Yes.
Much obliged.
Supplementary cause list, item number 1.
May it please your Lordship. Lordship, this is that Zima of the drug involved in the accident, your Lordship. In this case, your Lordship, I have the instruction that charge sheet had already been filed and a report on 22nd 9/2025 has been forwarded to the MACT, that means to the tribunal, your Lordship. So, as such, your Lordship, there is a claim, motor claim is pending before the tribunal, your Lordship. Lordship, kindly, this is the requirement under section 158 of the Motor Vehicle Act.
Okay.
So that order passed by the learned judicial magistrate is perfectly fine, your Lordship. Say, okay. No, fine. Lordship, kindly have the order. If Lordship kindly have page 18.
Yes.
If Lordship kindly have, kindly come to page 19, that is the judgment in Jai Prakash.
Yes.
Lordship kindly see that is the paragraph 21. When there is no insurance cover for a vehicle, admitted fine, your Lordship, the vehicle does not have a insurance policy. The owner should be directed to offer security for a deposit, an amount adequate to satisfy the award that may be ultimately passed as a condition precedent for release of the seized vehicle involved in the accident. If such security or cash deposit is not made within a period of 3 months, appropriate step may be taken for disposal of the vehicle and hold the sale proceed in deposit until the claim case is disposed of. The appropriate government may consider incorporation of rules on the line of the Rule 6 of the Delhi Motor Accident Claim Tribunal.
We are not on rules. Rules have not
Lordship,
come.
yes.
But then, what is the 3 months period is to be computed from?
Lordship, I think the 3-month period, your Lordship, if by this judgment, that mean is not made within
3 months. Within a period of 3 months means 3 months from the.
Lordship, I think it should be from the date of the, if Lordship kindly, then this has to be taken from 22/9. Lordship, kindly see the next, kindly turn the next page, your Lordship.
Yes.
Lordship, this is the information reported by the IO to the member of the Motor Accident Claim Tribunal, Nongpo.
What is the date of this report?
Lordship, kindly come to the first page, that is 22nd 9/25. Lordship, I'm sorry, 21st 9/25.
Yes. Okay then. There's.
So if it is released, released also, if Lordship is inclined to release, then he has to deposit certain amount of Lordship, as per the judgment in Jai Prakash, Lordship.
But that deposit will be made where?
Lordship, it has to be deposited before the tribunal.
No, whether tribal has any authority to release the vehicle?
No, Your Lordship. Because the release of the vehicle will be by the regular criminal code, Your Lordship.
So that can be done only after deposit is made.
Lordship, yes.
Now here it's a case where there is a contention that they have deposited already, they have given already 2 lakh rupees.
Lordship,
The victim
Lordship,
family.
that compromise, Your Lordship. Lordship, kindly have a page 15. Lordship, this compromise is, in my humble and respectful opinion, is against the law. It cannot be acted upon, Your Lordship.
Yes.
Cannot be acted upon, Your Lordship. Because under the law, under the MP Act, Your Lordship, there is a provision in case of accident or then the victim or anybody can file a motor accident claim, Your Lordship. This cannot be acted, Your Lordship. It is completely, Your Lordship, is.
Then which way we decide the amount which is to be deposited? On what
Lordship,
basis?
then the Lordship will direct the MPI to assess the cost of the vehicle.
It has nothing to do with the claim, amount of claim.
Lordship, because if we go by the judgment rendered in Jayaprakash, Lordship, it said that security has to be made, Your Lordship. Because admittedly, Your Lordship, the vehicle does not have a valid insurance policy.
Okay. Yes.
And I think one of the seniors here about.
Yes, Mr. Paul. You're not audible.
Am I audible now, Malaj?
Yes.
Yes, Malaj. Malaj, the limited issue which we had pointed out before your lordships on the last occasion also, the 2 judgments of the Honorable Supreme Court, Malaj, in this regard, they talk about a contingency, Malaj, where there can be a future claim.
You see, there is this as per the instruction obtained by Mr. Sulai, that
Malaj.
there already the report of accident has been forwarded and there is already a pending claim. So that is there. So long that claim remains, what is the question of releasing?
There is a, Malaj, that was nowhere part of the record. As a matter of fact, the police report which we pointed out in the earlier order, Malaj, says that
this has been placed before this court by Mr. Sulai right now. This was forwarded on 21/9/2025. The matters, yes, the report was forwarded to the member motor accident.
If I may
claim.
interrupt, Your Lordship. I'm sorry, Your Lordship. If Lordship kindly have the MB Act, Section 1586, Your Lordship. (1586), Your Lordship.
Subsection?
Section 6, Your Lordship. May I read it, Your Lordship?
Subsection 6.
Yes, Your Lordship.
Where is one six? This MB Act 1988, isn't it?
This Lordship is Section 6 has been added by Act 54 of 1994, Your Lordship.
Section, you are referring to section 158.
158, subsection 6, Your Lordship.
There is no subsection 6 here, 158. Motor Vehicles Act 1988.
Lordship, it is there, Your Lordship.
If production of certain certificates, licenses, and permits.
if I may read, Your Lordship. If I may read, Your Lordship, section.
Where is subsection 6? You are referring to the Act, isn't it?
Lordship, to the Act, yes.
Just see this book. Just
This Act, Your Lordship. No, Your Lordship, it is not there. It has not been. No, Your Lordship, it's not there.
How can that be possible? A reputed publisher has not incorporated that amended part.
Well, this amendment was brought out in 1994, my lords.
Yes, but then this book,
Book does not have it.
this is universal publisher, I think, isn't it?
Yeah, it is not there. That subsection C has been abolished. Where is that? Where?
My lords, may I make a prayer?
Because Your Lordship.
Since my learned friend has also placed some instructions before my lords, which we were otherwise not privy to. We'll complete our instructions with regard to this claim, because I had already submitted before your lordships, my lords, that as the Supreme Court says in the other thing, if we are required to make a deposit, my lords, we are willing to make that deposit as well.
Now then,
It is
what
not
is
a case.
see, you have made a deposit, but then it appears that this kind of settlement will not be acceptable, you see.
No, I'm not talking about
Because your
this.
claim is still
I'm not talking about this settlement, my lords. I'm saying making an additional deposit with the court.
So you make the
We
necessary
make-
deposit and then come for Jimma.
My lords, but unless, my lords, there's a direction from some forum, my lords, I cannot make a deposit on my own.
See, the thing is, if you go by the procedure, then what happens that your vehicle has to be assessed, the valuation has to be taken, and thereafter you have to be asked to make deposit.
My lords, let that be done.
No, but then whether that has been done or not, how do we know
It
it?
has not been done.
It has
That's
not
the
been. It has
difficulty.
not been done, Your Lordship. It has not. The assessment of the vehicle, what is the cost of the vehicle, that has not been. That
No,
has
but
not
then
been
at
done.
what stage it is been done? MBI is compulsory, isn't it, after accident?
Lordship, yes.
MBI report ought to have been done, my lords, at the first instance.
So if that is there, definitely valuation also will be there.
It must be there, Your Lordship, because
that is
the
why-
specific instruction I have sought from the police, not from the MBI, Your Lordship.
So see, like even if it is done, if valuation is done, police will have the information about it. So without those information, we cannot pass any order in the air.
My lords, may I pray, let my learned senior just produce the records before this honorable court, my lords.
Now, if you are seeking release,
My lords, I am saying
then
that if I am
that
required to make a
is it
deposit,
not
I am willing
onus
to
is
make a
on you?
deposit.
See, the law is
I'm
very
sorry,
much
I'm
clear.
sorry.
We do not. We see like it is undisputed that you have to make some deposit. Now that deposit
lords,
which
I
has
should
been
know-
made or not, you
My
have
lords,
to satisfy the
what
court.
I'm only saying is, I want to know, my lords, what is the figure that I should deposit, my lords, I am willing to make that deposit.
So that is where. So you have to see. You have to first inquire whether the motor, whether this vehicle was
Assessed or
valuated
not.
or not. Yes, it was assessed or not. See the valuation.
My lords, that would be all reflected from the case diary of that particular case. my
And
lords.
then onus is on you to find it out. You have to find it out. If it is your case, you cannot shift the burden. If you say that has not been done,
But
then
it's
make
the-
a statement say it has not been done.
My lords, I'll obtain instructions on this, my lords. May I pray, your lordships, have it day after tomorrow, my lords. In the
Lordship,
meantime,
I
I'll
do
just
not
obtain
know,
instructions.
Lordship, it is 159, Your Lordship.
Yes, so that is-
159. Information to be given regarding the police, Lordship.
159, no?
159.
159 surplus. Oh, it is on section 159. Yes.
Lordship, yes.
So there is no incorporation of subsection 6.
Lord.
That is not there.
That has been amended by the Act of 2000.
No, whether there is to be subsection 6 in 158.
Lordship, yes. Okay, it is there, Your Lordship.
So far as this book is concerned, it is not there. And no indication also.
Lordship, yes.
At the footnote also that has been omitted or repeated. Nothing
Lordship,
is
it
there.
appears
Added,
that has been
substituted,
omitted,
or
Your Lordship. And it appears that by 2019 Act, that has been incorporated, Your Lordship. So it is the duty of the police officer, Your Lordship, to report accident to the tribunal.
So you see, the police officer shall bring the accident information report, the settlement of the claim. So definitely accident information report will be there. I think there
Yes, Your Lordship. That is what I have placed before Your Lordship.
No, but then, what about the valuation? And which way you ask
Lordship,
them?
the valuation, Your Lordship, that has to be assessed by, I think, by the MBI, Your Lordship. It has to be assessed by the by the MBI, Your Lordship.
Now, how do you know what is the status of this claim before the MSCT?
Lordship, that has been forwarded only on 21/9/25, Your Lordship, because
Yes, we are in December now.
because the requirement of the Act is that
3 months.
the incident report, Your Lordship, will have to be intimated even to the insurance. But admittedly, Your Lordship, here we don't have the vehicle doesn't have the insurance policy, Your Lordship.
That is why
So
the
that
vehicle
is why, Your Lordship, that Usha Devi case came into.
No, we understand. But then, what is the solution now?
The solution, Your Lordship, in my humble and respectful submission, Your Lordship, they'll have to deposit, they'll have to make that security, Your Lordship.
But then, which way we ask them to deposit the security?
Lordship,
Just tell
then
us, what is the amount of security?
then Lordship will direct the trial court to ask the MBI, Your Lordship, to assess the cost of the vehicle. And that cost will have to be deposited by the applicant before the tribunal, Your Lordship.
Yes, Mr. Paul. It appears to be quite fair.
Fair proposition. I am willing to make a deposit as long as I'm told, my lords, what is the amount that needs to be paid. That my difficulty
Because
is, my lords, that I don't
admittedly, Your
even know.
Lordship, it is a case of death, Your Lordship.
Yes, yes, yes.
A case of death, Your Lordship. So it'll come. I don't know what is the provision of the disease. Because I have not. I don't know. It'll come in lakhs, Your Lordship.
No, it's okay. You also do not have any objection if they make the deposit.
No, I don't have, Your Lordship. I don't have the injection. Because what I'm concerned, Your Lordship, I'm concerned about the victim.
We can direct the which is the court, appropriate court?
Lordship,
The judicial magistrate.
judicial magistrate,
Judicial
Yes,
magistrate.
to ask for the valuation of the vehicle.
Lordship, and then he will deposit that money before the tribunal, MST, Nongpo.
Okay. That is.
And my lords, on such deposit, my lords, my vehicle, my prayer for Zimma would be positively considered, my lords.
Definitely, we will say that once you
Right.
agree to deposit this, say that is what we will
My
say.
lords.
Yes, heard. Mr. Capel, London Senior Counsel, appear with decision by Mr. Tapal, counsel looking for the petitioner, and also Mr. Andy Shulai Lana DAG, appear with. So, G. Stop. Paragraph. But this application. What is this? This 438 is it is corresponding to what is the?
Lordship,
It is 397 and earlier.
No, it should be 456.
This is a revision, isn't it?
My lords,
397 or
it is
401?
under the BNS now.
Yes,
It
it's
will
all right.
be
it's all right.
401.
Okay, but this application
it's a revision,
Petitioner is-
revision there.
challenged. The impugn order dated 11/11/2025 passed in Jimma application number 147 of 2025 by the Chief Judicial Magistrate Nongpo, by which petitioner prayer for release of what is the vehicle?
It's a truck.
It's a truck. My lords, I think it's a dumper truck.
The release of his vehicle bearing registration number ML
Dumper truck, Your Lordship.
The
ML10
dumper truck.
X1010.
1010 with the respective rust dumper truck was rejected. Stop. The petitioner has also prayed for passing of necessary direction for release of the said vehicle. Stop paragraph. The fact, this paragraph, the brief fact of the case is that the vehicle of the petitioner was allegedly involved in an accident which resulted in death of where this accident took place?
The lordship should find at page 13. Just a second, please.
It occurred at Sumer, my lord, Umbang.
Umang ballots.
My lord, can you have page 13, my lord, is the copy of the FIR.
Page
FIR is there.
13.
Annexure 1, Your Lordship.
which is what is it? What is it? Which resulted in death of one person at Prison vehicle was allegedly involved in a road accident which took place at such and such place. At Sumerumbang,
Sumerumbang.
River district, resulting in death of one person. Stop. Consequent to the accident, a police case by Umiam PS case number 87 within bracket 09 2025 under section 281 stroke 106 within bracket 1 BNS was registered. Stop. Thereafter, the vehicle of the petitioner was seized. By the police. Stop. It appears on the record that petitioner had approached the learned court of the Chief Judicial Magistrate for release of the vehicle by filing a Jimma application. How many times you moved for Jimma, Mr.
It was moved twice, my lord. On the first occasion, it was withdrawn.
Okay.
For some technical issue.
Anyway, what is it? It appears that the petitioner has approached. By filing Jimma application number 147 of 2025. Stop. The learned Chief Judicial Magistrate by imping order dated 11/11/2000. Oh, impute order dated 21/10/2025. Rejected the said application of Jimma on the basis of the proposition of law laid down in the case of Joy Prakash versus so and so, and another one Usha Devi versus so and so. These references you will get it in page 7 and 8 of the petition. Okay, you will get these citations also, write the citations also on the basis of so and so, by holding that the vehicle of the petitioner was not by holding, as the vehicle of the petitioner was not insured, against third party risk. What we said? As the vehicle of so and so. Stop. As the vehicle of insurance. Stop. The landed court had held that the petitioner has not offered any security or deposited any amount adequate to satisfy the award that may be ultimately passed. Come on. The vehicle cannot be released. Stop paragraph. The landed senior counsel appearing for the petitioner submits that the petitioner has made an attempt to settle the matter with the family of the victim, and in pursuance thereof an amount of rupees 2 lakh has already been paid. Stop. He further submits that, yes, Mr. Thappa, you are ready to make the deposit. That is
Yes,
what
yes,
he is.
Lord.
He further submits.
As per the valuation.
Yes, the petitioner is willing to offer adequate security for the release of the vehicle, but as the exact amount of such security is not known to the petitioner, he is unable to offer such security. Stop. He therefore submits that the appropriate authority may be directed to assess the valuation of the vehicle,
Valuation, Your Lordship, yes.
of the seized vehicle, in order to decide the amount of security to be offered for release of the vehicle on Jimma. Stop. Stop. Mr. Learned AG appearing for the state. Submits that the impugn order dated 22/10/2025 passed in Jimma application number. What is the Jimma application?
There are two applications.
So now see, now we are referring to Jimma application number 131, not 147.
The main order is 139 now. The main order, rejection order is 139.
Then what is it? What is that?
The other is, my lord,
Page 18, Your Lordship.
the other, the page
Zima application 139/2025.
No, but then
147 is there. That
then
is
thereafter again 147 is there, Mr. Shulai. 11.
that is an
11,
appeal order, my lord. I mean revision order, my lord.
That is.
Revision order, my lord, before the CGM.
Now this is a second revision.
Sorry, my lord, this is the second. I think
Not maintainable under law.
22nd 10, my lord, is the first Zimma application.
That is all right, but then
1111 is again a second Zimma application. My lord. That
Okay,
is
so-
that also stands rejected.
oh,
Then that the applicant would not be maintainable, Your Lordship. A second revision will not
No,
lie.
it's not, it was not a revision, my lord. It was filed twice.
twice. That is what the
Yes,
order
the
is by
second
chief
bail
judicial
application
magistrate.
got rejected on a
So now
ground
you
that
should have pointed
there's
out.
no change of
See,
circumstance.
it appears that there are three applications then. First one you have filed on 8/10, it was withdrawn. The second
13,
application was
13/10, Your Lordship.
17/10, which was rejected. And the third
13/10
application is 147.
I'm sorry, my lord. A mistake on my
This
part.
court has gone on the
I'm
premise that there
mistaken
were
on
only
my
two
part.
applications.
There are three applications.
Now on the first part you have to correct the beginning part. Just starting part after the where the vehicle was, he filed an application under, we said like Jimma application number 147 was filed. Where you have said it? No, you do not have to say read that much. After the facts of the case, where you have narrated the fact of the case, and then after we said FIR was registered and the vehicle was seized, and thereafter Jimma application dated, the Jimma application number 147 of 2025 was filed. Where you found it? But what is just read that part? No, you just say it appears from the record that the petitioner has approached the court of the Chief Judicial Magistrate on several occasions, on more than one occasions, or rather you say several occasions for release of the said vehicle. However, such prayer was rejected by the court below by order dated 22/10/2025 and 11/11/2025. All right. So that covers up that line till where is it order? And what is the next line then? Now there you have to challenge these things. We have said already that it was rejected by two others. Then there you just say being aggrieved. the petitioner has approached this court for release of the vehicle, release of the seized vehicle. Okay, and then comes the whole submission part, isn't it? And then just say, Mr. Sulai Learned AG appearing for the state respondent submits that the order of rejection passed by the court of the Chief Judicial Magistrate, orders of rejection, there are more, do not suffer for any infirmity or illegality, as these are based on, as the orders are based on established proposition of law. Step. However, the learned AG submits that if the petitioner is willing to furnish, you need to deposit the requisite amount or is ready to offer adequate security for the release of the vehicle, the state will have no objection
Lordship, yes.
to such release on Jimma. Stop. Paragraph. Upon hearing the learned counsel on learned counsel appearing for the parties. This and on perusal of materials on record. It appears that pursuant to the occurrence of the accident, the matter was informed to the Motor Accidents Claim Tribunal by the police. Stop. However, there is nothing on record as to nothing on record to show that whether the vehicle seized by the police, the valuation of the vehicle or the value of the vehicle seized by the police was assessed or not. Stop. Therefore, in the interest of justice, this petition is disposed of by directing the Chief Judicial Magistrate to issue necessary direction to the appropriate authority to assess the value of the dumper truck number so and so, which was seized by the police. Stop. It is provided that after the valuation of the vehicle is done, if in the event No, just do not say. Do not just say. Just say to assess the vehicle. Stop. Then it will be open to the petitioner to file a fresh GMO application before the appropriate court. After the vehicle, the petitioner is assessed by the concerned authority. Stop. In the event petitioner files such application, comma, the learned Chief Judicial Magistrate shall release the seized vehicle to the petitioner in the event petitioner is ready to offer appropriate security for such release in accordance with law. Step. The learned court, the learned Chief Judicial Magistrate, while releasing the vehicle on Jimma, on fulfillment of the above condition by the petitioner, may also put some other condition. Also put some other condition for such release, if it is found necessary for the interest of justice. Step. In the above, this petition is disposed of. Yes. There may be some correction, there is some repetition.
Oblige, Your Lordship.
Item number 2.
Yes, Mr. Sneaker.
Yes, my lord, this is a case where the petitioner's brother has married respondent number 2. So they've got a relation is not good between them. And just to teach a lesson and take revenge, she has filed this FIR against the petitioner, who is married already, having 2 children and living somewhere in district Soritpur. But only because she is the sister of her husband, she has lost the FIR.
Just a minute, just please say it again. The petitioner, who filed a FIR against the petitioner?
Petitioner's sister-in-law, that is petitioner's brother's wife.
Okay. Petitioner's brother's wife.
Yes, my lord. So now
that is-
petitioner's brother has got a strained relationship with the respondent number 2. So she has approached the domestic violence and filed the FIR, and case is registered against her.
Okay.
The case should be between the husband and wife, that is separate. She is not even in a domestic relation with the respondent number 2. They are not living under the same roof. She is somewhere Sonitpur. This petitioner, she is married and she is living with her husband and children in district Sonitpur, my lord. But still domestic violence will come when there is a domestic relation between the parties.
And the alleged incident took place here in Shillong.
In Shillong, yes, my lord.
FIR is registered here in Shillong.
Yes, my lord.
And this lady, the petitioner,
Yes,
she is
in
also in
Sonitpur.
burden. She has been.
Yes. So it is an attempt to harass her. She will have to come maybe now and then, and her conjugal life will be spoiled because of this false allegation. How can she come and torture the sister-in-law here when she is living with the children and husband?
They cannot be mental torture by telephonic call.
No such allegation is there, the telephonic call. Only torture is there. So let the notice be issued. Let us see what happens.
Yeah, let the notary be as if upon respondent what to your lordship.
At Mr. Siddiq Learned Senior Counsel, assisted by issue notice returnable in 3 weeks. Mr. Abraham Learned GAPS for the respondent number.
One, your lordship.
Steps for service up to the respondent number 2. We taken with the 2 days. Step will be taken with 2 days by the petitioner. Step. List after 3 weeks.
Well, record may be called for, otherwise how we will know this?
We'll see later.
So,
What? Which record? FIR. Can we go into facts and
course not.
decide your plea of alibi?
yes.
And please, your lordship.
Item number 3.
Yes, what is this?
Lordship, the matter has been heard. Lordship wanted to publish the judgment referred in the 2 decisions which I had relied. That is of
Oh,
Biswajit
this
Dey.
Vishwajit Dey.
Biswajit
State of
Dey.
Assam, yes.
So I have furnished Lordship copy of the judgment.
Here there is a, what is the allegation, nature of allegation in your case?
In your my case, Lordship, the allegation is that the vehicle has been intercepted, and the owner, or Lordship, the driver and the handyman, they run away. They are absconding.
No, there is an allegation against you or no?
No, Lordship.
Yes, Mr.
Here, Lordship, here two vehicles are involved. In this case, Lordship, the driver of one vehicle has been arrested. Here, the driver of this vehicle, he fled away from the spot. could not arrest the driver. Then Lordship, the notice were issued to the owner. Then owner also not complying, Lordship. Now here the contraband is more than 200 kilo, that ganja, Lordship.
Yes, it seems difficult then, Mr. If you are not cooperating, your notice was also issued to also.
No, Lordship, I have never
Your
received the
driver
notice.
has. Your driver has.
I have pleaded, make a aberment in my petition, Lordship, that I have never received any notice.
Then how
Otherwise,
we will decide that?
what is prevented the police to go to that my place of residence? Lordship?
I'll just hand over the instruction, Lordship. Yes.
These NDPS cases are problem, Mr.
Lordship,
Maybe
here the
in other
vehicle is
cases-
under finance. The Biswajit case also.
It's all right. See,
it
that
is on
no exemption
finance.
is made on that.
Lordship.
You are Ratan Dev Barma.
Lordship.
He's the owner of the.
You have just given it to show the name of the owner only.
Lordship, that vehicle number 2, Lordship, serial number 2.
Yes.
Then below the next page, Lordship, will be next page, yes, Lordship. Last,
Okay.
the last paragraph, Lordship.
This is TR05F 19009.
09,
the
yes,
vehicle?
Lord. 1909, yes, Lordship.
Yes. There is allegation against you, Mister. You will be, if you are guided by this Bishwashit, the case which you have, the other decision which you have relied on, these all are based on Bishwashit.
Lordship.
Then you do not have a good case for release. There is allegation against you. Yes. Sorry.
In paragraph 7, Lordship, I have pleaded that I have never received any notice.
Whatever it is, but then there is a allegation against you, and that is what
The
Bishwashit.
vehicle is under finance, Lordship. If the vehicle remains in the
What to
police
do?
station,
See,
it will.
if it is, see, your vehicle, it was modified in such a way so that you can, you see, carry things in a such of this kind of things. That is what the indication is at this stage. What to do?
The vehicle,
See, you
Lordship,
can-
it
you
was
can-
handed over to the person. And he had under a contract, Lordship. Para 3 I have mentioned.
That is all
he
right.
had to
But
pay.
then, you see, you may,
Then
you may
the
say,
entire
see, Mr. Upadhyay, just be realistic of one thing, that we are not in a position to decide whether you are guilty or you are innocent at this stage. Now, if you go by the very propositions which you have relied upon, you have to see what is the nature of allegation. And this, it appears that there is a direct allegation against him. This has been said that even they say like you were strongly involved in the crime.
that is a part of investigation. That is
And that is what we have to see at this stage.
Lordship. Here I am before Lordship for the Jimma of the vehicle. If it is released, then
That is all right.
It
Even for Jimma, we have to consider that. That is what the decision which you have cited it says.
and as far as the about
See,
the
Ganesh-
notice, I have
Ganesh-
never received any notice, Lordship. And
Dinesh
what?
has been cited by you, isn't it?
Yes, 3 decisions I have cited.
So
Lordship.
we are going by the principle of Dinesh then. If you say that Dinesh follows that Vishwajit there,
Yes, it's
Then-
reliable.
then if it is relied, then
And here, Lordship, the case has been charge sheeted, and moreover, the vehicle had been lying for more than 5 months, Lordship.
what
Or
to
1
do
year,
with this?
5 months.
What to do if this offences are like that? Then what to do?
I'm asking. Prayer is only for the interim release of the vehicle. That's all.
That is, you see, that is cannot be absolute release at this stage. There has to be an. If court wants also, you cannot grant you release.
Not sure.
Because there is no cooperation by you. No cooperation plus you are a strong suspect. That is what they say, report says. Mr. Upadhyay, this is not only once. Notice has been issued to you several times.
But I have not received. That is what I have stated, Lordship. On oath. Para number 7.
It's all right, we cannot decide it.
Lordship.
Yes, heard. Mr. Upadhyay, direct counsel for the petitioner. And also Mr. Sheikh Learned Counsel, praying for the respondent. This order, granting or refusing Jimma, is revisable.
My lord, in the that judgment which Mr. Upadhyay is relying, that also has come against the order of revision, Lordship. And,
Order in revision means?
that criminal revision.
No. This is a revision against the order of
Against
rejection.
the order, yes, Lordship. There,
So,
are,
revision is otherwise material.
there is diversion of opinion by the High Court, Lordship. This is maintainable, Lordship.
Whether it's a final order or not, or interlocutory
Lordship.
order or not. Okay.
And
We are
here
not,
in this
since
case-
none of you have raised that
Yes,
issue, so we
Lordship.
are not going into that. All right. No, so and so. Stop. The paragraph. The petitioner has approached this court, being aggrieved. On being approached this court on being aggrieved by. The MP in order dated 22/7/2025, passed in Jimma application number 7 on 2025. By the who passed the order?
Special Judge Nongpo.
Special Judge.
By the
NDPS.
by the Landed Special Judge within packet NDPS Nongpo in Jimba application number 7 of 2025, arising out of criminal. Sit down, you please. Criminal NDPS case number 1 of 2025 under section. Just see from the cause title of the petition. Rejecting the prayer of Jimma of Maruti Suzuki Super Carry Pickup vehicle bearing registration number TR05 stroke F dash 1909. Stop. Paragraph. The brief fact of the case is that on 24/7/2024, petitioner's vehicle along with another vehicle number TR04 stroke D1920 were intercepted by police. Of what is the thing recovered, Mr. Sheikh, from the vehicle of the petitioner?
Ganja, Lordship.
This is marijuana.
Yes.
And what is the quantity?
Quantity, Lordship,
You said earlier
266 kilo, Lordship.
from the vehicle of the
Yes. From the two vehicle.
from the two vehicles.
Yes, Lordship.
But then it is mentioned here is 236.89 kilo.
Yes.
So you say 266.
Yes, yes, from the two vehicle, Lordship. That is at page 3, Lordship.
Page 3 of
3 of my instruction, Lordship, which I have received, Lordship. I have put the highlighter, Lordship.
where is the 266.89?
89, yes, Lordship.
Their petition they say 236.89.
Yeah, this is because two vehicles are involved, Lordship.
Is it? So from other only 30 kilo.
Yes.
From one only 30 kilo.
Yes. That also commercial. Because above 20 is.
Just what we said, the last line. Were intercepted by the police. And on search 266.89 kilo of marijuana was recovered. Stuff. Consequently, MPS case number 64 of 2024 under section you will find it at para 4 of the at page 5 of the petition was registered and the vehicle of the petitioner was released, was seized along with the other vehicle. Stop. The petitioner thereafter filed Jimma application number 7 of 2025 before the learned special judge NTPS, Rivai district, Nangpo, for a release of his vehicle number. For release of his vehicle bearing registration number tier 05 stroke F-1909. Stop. The learned special judge, after hearing the parties, rejected the prayer of the petitioner by order dated 22/07/2025 petitioner being aggrieved has now approached this court. Mr. Mr. Upadhyay Rana Counsel appear for the petitioner submits that the petitioner is no way involved with the alleged commission of the crime, and the vehicle also and the vehicle in question is also entrusted with the driver. And with the driver in good faith. And the petitioner right now, the petitioner is no way connected with the affairs and business of the vehicle. Stuff he submits that the vehicle is used by the driver under a contract. Where is that contract?
Lordship, it was mentioned in para 3 of the.
Okay, your contract you have not enclosed.
No, Lordship. This was all oral contract, Lordship. That he will pay
oral
weekly
Okay.
5,000 rupees. And the entire management of the vehicle and parking will be his lookout.
What? Just last. Just say. So there is no contract then. Where is the contract then?
Lordship, this is only
This is
that he will
normal
pay.
thing. The driver, he drives the vehicle, he does the thing and comes back.
entire management of the vehicle is given to him, and he has to
do
pay
not
the
say, do not write
5,000
this part
rupees
of the
per
contract. We
week.
just cancel this contract. It's run under a contract. We just cancel that line. It is submitted that the driver of the vehicle has been engaged on contract work basis. Who? He is entrusted with the work of transporting goods. And for parking the vehicle at his own risk and cost. Subject to payment of rupees 5,000 to the petitioner every week. Stop. He therefore submits that the you don't say he therefore submits. Moreover, the learned counsel submits that the vehicle was procured by. Where you have mentioned it? That finance?
Finance that is enclosed at annexure.
No, no, have you mentioned it in your thing? You have not mentioned anywhere.
Lordship, I have mentioned.
You have not said.
I have in the ground.
The vehicle was procured by obtaining financial assistance from bank and the petitioner has finished. Repay the loan on installment basis. Stop. He therefore submits that until and unless the vehicle is released on Jimma to the petitioner, until and unless the vehicle is the petitioner will suffer irreparable loss. An injury. Step. He therefore prays that necessary order may be passed, granting Jimma of the vehicle to the petitioner. Step. The Honored Counsel has, in support of his submission, the Honored Counsel has placed reliance of the reliance on various decisions of the apex court in there will be these two matters, Tarun Kumar Maji and Danesh. Stop. Next, Mr. Sheikh, Knowledge GA, appearing for the state of the other hand, strongly objects to the prayer made on behalf of the petitioner. Stop. The learned stop. He submits that the have you disclosed the detail of the driver? Who is your driver? You have not mentioned. He submits that the details of the he submits that the driver of the vehicle number TR05S1909 is absconding, and details of the driver is not disclosed to the police by the petitioner. He submits that both he submits that the petitioner and the driver are both evading arrest, and the petitioner has not appeared before the police despite several notices were sent to him. He further contends that the petitioner is strongly suspected to be involved in the matter, as the vehicle of the petitioner is modified in such a way, he has modified to create several hidden compartments in the vehicle in order to conceal the materials carried in the vehicle. He therefore submits that the release of the vehicle at this stage will be detrimental to the interest of the case and would cause hindrance to the further investigation of the matter. The learned GA therefore submits that there is no merit in the matter. There is no merit in the prayer made on behalf of the petitioner and prays for rejection of the application, rejection of the petition, of the present petition. Upon hearing the non-counsel for the parties and perusal on materials on record, it appears that a huge quantity of marijuana amounting to okay. What you said? Perusal matter. It appears that on 24/7/2000, 24/7/2024, isn't it? Yes, 24/7/2027. A huge quantity of marijuana was recovered from the vehicle of the petitioner bearing registration number TR005F1909. Which was kept hidden in the compartment of the upper portion of the vehicle. You have to cut the vehicle to bring out these things. The upper part of the vehicle
Yes,
has to
Lordship.
be.
Because he made some compartment and
The report says
yes, Lordship, the report that the IO has to cut the
contravention was to cut the upper portion of the vehicle. The only possible way to take out the whole contraband was to cut the upper portion of the manufactured floor, which led to recovery of. What is it? The last. Which was just a minute. Which quantity of marijuana amounting to? Which one marijuana? Yes, amounting to 266.89 kilo. Was found to have been concealed. Stop. The police had to cut the upper portion of the manufactured food to recover the contraband which were concealed there. Stop. It also appears that immediately after the detection of the contraband, the driver of the vehicle and his helper fled away from the scene. And they are yet to be arrested till today. The status report of the case shows that several notices were issued to the petitioner for his appearance before the police, but he also did not. But he failed to do so. Stop. It appears that the detail of the driver has not been disclosed to the police by the petitioner till date, and as a result of which none of them could be apprehended by police. It further appears in the report that the vehicle was intentionally modified in such a way to create special hidden compartment to carry contraband in a concealed manner. Stop. The fact of the situation reveals that there is allegation against the petitioner, and his role is strongly suspected. Stop. Since the petitioner has not come forward to cooperate with police, and no details of the driver is furnished to the investigation by the petitioner, by the investigating authority to the petitioner. This court finds that at this stage finds that the release of the vehicle at this juncture will be detrimental to the interest of the case. There is every likelihood that the investigation of the case would suffer if the vehicle is released at this stage. Stop. In view of the law, there is no merit in the petition. The same is rejected. Sorry. Yes.
Item number 4.
Yes.
See, the matter is still pending in division bench, and it may be adjourned for 4 weeks.
It's submitted. Yes.
Mr. Ndishula is currently on his legs, Your Lordship. He's a.
No, is it correct this matter is pending before DV?
Division bench.
Yes, Your Lordship.
The London Council appeal with the parties. Submit that. Yes.
My lord, yes, the actual appeal, my lord, it's still pending before the
That
division
is what
bench.
Mr. Qureshi has submitted. That.
My lord, yes, the matter will be taken up in January, my lord, 2026.
Yes, just as the decision in the connected matter pending before the division bench is still awaited.
It's okay.
Come on, list this matter after. Revocation.
Item number 2.
Yes.
His Lordship, the respondents have to file their affidavit in this matter.
Some more time to file, Lordship.
Yes. Any objection?
No objections, Lordship.
Yes. As paid for by the London Council appealing for the resolution number 2. Further 3 weeks time is granted for filing affidavit in opposition.
By 2, my lord, respond number 2.
Resolution number 2. State is not filing.
State is not filing, my lord.
Lordship, I pray for the extension of the interim order.
There is an interim order.
Yes, Lordship.
Where is that is passed in which case?
In Miss Case number 3 of 2025, Lordship.
This case number 3. We'll make it until further order then.
My lord.
Yes. This list is matter along with the main case. Stop. Interim order. If any. First earlier. Shall continue until further order.
My pleasure, Lordship.
Yes.
Item number 3.
You filing anything?
What is this matter?
This is regarding the quashing. The complainant and the accused both they have settled the matters. Actually, it was a not compoundable. Only one of the sections is not compoundable.
What is the offence involved here?
Offence is the 323 and 354.
323 is compoundable.
Compoundable. 354 was compoundable prior to 2009, but after 2009 it was not compoundable. So we can't. They have settled the matter. It's more very. It happened due to a misunderstanding only. In fact,
There's a private
the
respondent.
state there's no. Only because he went to collect the.
Yes.
Your Lordship, in this case, the first party and the second party, the first party should have been met as a respondent, but they
I have no
come with a
consideration
joint.
against first party.
That is required to, you see, like,
It's a
for
settled
determination of fairness. You do not know what happens outside. You do not know how you have obtained consent.
If I'm pleased to take Your Lordship to page 10, that is FR, Your Lordship.
Yes.
FR was filed the bottom E. Balari Rani. She was the one who filed an FIR. E. Balari Rani.
Yes.
Then if I'm pleased to take Your Lordship to the compromise, that is page 26. Page 26. Compromise. The deed of compromise. Page
Yes.
26.
Yes.
It's written only E. Rani. So there are two persons.
No, it's not 2%.
E. Rani, and in the FR it said that E. Balari Rani.
Here.
And if I'm pleased to take your lordship to you.
See, yes, Mr. The signature also appeared to be quite different.
Yes, lordship. So he should have been made
The
as a
signature, if you compare, it appears to be quite different.
Here, lordship, I have one more. The complaining, examine.
Then even in the course title, it is written as Ibalari Rani. Course title, your lordship, that page 2, course title. Srimati Ibalari
Here
Rani.
in this page 17. Page 17 is the deposition of the complainant. Here she said, my name is Srimati Miss Ibalari Rani. She is the complainant in this case. She came and deposed before this court during the trial. And here she said, I received a summons from the court to depose before the court. The incident happened. She is the only person here. We have enclosed the copy of the...
We list it for hearing.
Yes, your lordship.
You have obtained your instruction.
Yes, your lordship.
Because this signature appears to be significantly different.
Different, but...
you see, it is not only for the purpose of missing of word, this Ivalari. You see, the very way the E is written is totally
written,
different.
yes.
Totally
But the deposition is there.
See, if doubt arises, then we do not know. This is something...
They will appear before the court. Sorry.
This is the problem, if this party, they are in collision and they come together,
But
then it becomes a problem.
in the deposition also she signed.
This court will not go, to evaluate, to determine who has signed or not. It is good enough if any doubt arises. Anyway, Mr. Abraham Landetji, appearing for the state respondent, submits that he has obtained necessary instructions in the matter. Expect for the parties, list for hearing, after vacation.
Hello, please.
Item number 5.
May it please your lordship. Your lordship, I seek to withdraw this petition with a prayer for liberty to file afresh.
Yes, Mr. Nath.
I am appearing on behalf of...
It has been withdrawn. It is sought to be withdrawn. What is the matter about?
Your lordship, it involves a loan agreement, and based on non-repayment, an FIR was lodged on the lines of forgery of the security documents that had been submitted against the loan.
So there is allegation of cheating financial institution.
Yes, your lordship.
The document, forged document.
Okay. Anyway, since he's withdrawing, he's asking for liberty. Any problem with that?
I have no objection, your lordship.
Mr. Singh,
Yes, your lordship.
Learned Counsel, for the petitioner on instruction, submits that the petitioner does not wish to press this application and prays for permission to withdraw the same with the liberty to file afresh. With liberty to file afresh. Stop. Learned Counsel appeal for the respondents have no objection. The next is a prayer allowed. This criminal petition stands dismissed on withdrawal with liberty as prayed for. Yes.
Grateful, your lordship.
Item number 6.
Yes.
It's for last order day.
Lordship, offering for some more time to file the objection.
What is this matter about?
Restoration petition, Lordship.
Restoration petition, your lordship.
Okay. Restoration application.
Yes.
And there was a marathon hearing for condemnation of delay. This is the matter.
Yes, Lordship.
And then we found that the petition doesn't lie. Yes.
No objection, Lordship.
Expect for the. You are for the respondent number?
1.
Expect for the.
Lordship, for responding form, we are not filing objection.
You are not filing any objection. So, have you entered appearance before? No. Oh, Mr. Day appeared.
Yes.
They appeared, yes.
Mr. Day was there before. So anyway, we'll see to it later. Okay.
Yes.
Or you want it to be registered, recorded? They will not find an objection. See, we just miss. E. Dakhar Learned Council appearing for the restaurant number 4. 3 and 4. 4 and 5. Are you sure? It submits that no written objection will be filed on behalf of the said respondent. Stop.
State is 2 and 6. State is just a formal party, Your Lordship.
Hmm?
State is a respondent of 2 and 6. State is just a formal party in this case.
2 and 6.
2 and 6, yes, Your Lordship.
Mr. Abraham also. So you also not find an objection?
No, Your Lordship.
Mr. You first say Mr. Abraham. First, before you write her submission, you say Mr. Abraham Leonard G appearing for the restaurant number
2 and 6, Your
2 and
Lordship.
6 submits that state being a formal party. Come on. No affidavit, no objection is required. No written objection is required to be filed on behalf of the said respondents. Stop. Then you say Miss so and so appearing so and so praise for okay, Miss appearing so and so for so and so submits that no written objection will be filed on behalf of so and so. Then you will come to Mr. Khongsi, Learned Council appearing for the restaurant number 1 and
What? Just one.
1. Praise for grant of some time for filing objection in the matter. Prayer allowed. List after 3 weeks.
Hearing item number 8.
This matter, my lord, can be posted after vacation, my lord.
This has to go after vacation. It will not be
Lordship,
possible.
it's pending for just.
It's all right, but then cannot do anything. It is not possible now. He can. There are already number of matters reserved by this court already. We do not know when we will be able to clear it. If you keep it also, it will be useless. Court will forget whatever submission is made. So just try it immediately after opening of the case. Yes, on prayer made with the Learned Council for the petitioner. List after vacation. Yes.
Item number 10.
Any information about the petitioner?
Lordship, the petitioner is in person.
In person, he was earlier occasion, Mr. Picabora, isn't it? Earlier occasion, the court was informed that he is under medical treatment. We'll just see. We'll just see. None appears for the petitioner. Mr. Sheikh Learned GA is present on behalf of the respondent number 1. List after application. Yes.
11.
Yes.
If may please your lordship, learned senior advocate Dr. N. Mosika is leading the matter. Due to some personal difficulty today, your lordship, I'm praying for some accommodation.
Yes.
No objection, Lordship. Let it come after vacation then, Lordship. Anytime convenient, Your Lordship.
Your lordship, I'm also praying for extension of the interim order, your lordship, status quo to be maintained by the parties.
This is your first appearance today? Okay. Okay, well, the appearance will be recorded. Just on prayer, we don't miss. Second run it. Counsel appearing for the petitioner. This is matter after. And also not objected to by Hilani Council appearing of the respondents. This is matter after vacation. Interim order, if any, passed earlier, shall continue till the next date.
Highly obliged, Your Lordship.
Your Lordship, I'm sorry, my lord, I couldn't make a mention seeking listing of one urgent matter tomorrow, my lord.
You have missed the bus. Try it.